Hello everyone, welcome back to my channel. And this series is about the civil procedure cold call preparation. And if you are also taking the civil procedure case course and also preparing for the cold call, you can join me. Today's case is Ashcroft versus Iqbal. It's a very significant case. Case ID. So the case name is Ashcroft versus Iqbal. And then the court is U.S. Supreme Court. The judge is Kennedy, and majority opinion. And the date of the case is 2009. The parties. We have two parties here. The plaintiff and also respondent is Javed Iqbal, and he was a Pakistani Muslim, and he was detained after 9/11. And the defendants and petitioners are John Ashcroft, and he is the U.S. Attorney General, and also Robert Mueller, and he is the FBI director. Okay, procedural posture. So how did we get here? Iqbal filed a complaint alleging the Attorney General and FBI director unconstitutionally detained him based on his race and national origin. It is about the discrimination, and also he claimed that he got harsh confinement. And after the complaint, the district court denied motion to dismiss. Oh, okay. So before that, the defendant filed motion to dismiss, and district court denied the motion to dismiss. And the defendant appealed to the Second Circuit, and the Second Circuit affirmed the district court's decision. And they are saying that the allegations are sufficient. And eventually the case was brought to the U.S. Supreme Court. The U.S. Supreme Court granted cert and reviewed the case. And that's what we are studying here. So we are studying the Supreme Court's analysis. Okay, the facts, some background about this case. After 9/11, Iqbal was arrested and held in the Mag Shoe. So this is kind of like a prison, right? So it's the condition were pretty hard, and so the plaintiff alleged mistreatment such as the physical abuse, denial of medical care, religious discrimination. Therefore, the plaintiff sued Ashcroft and Mueller, claiming they directed policies targeting Muslims. The problem is the federal court bars vicarious liability, so that means the plaintiff cannot sue the U.S. government. Instead, the plaintiff can sue the personal involvement in the discriminatory action if they have the discriminatory purpose. So that is the background for this case. The issue for this case is, did Iqbal plead sufficient factual matter to state a plausible claim that Ashcroft and Mueller intentionally discriminated against him based on race, religion, or national origin? So some rules the Supreme Court applied are the Rule 8A2, requires short and plain statement showing entitlement to relief. And also the Rule 12b6, complaint must state the claim upon which relief can be granted. And also we refer to Iqbal's case, and there are several standards we might apply in the analysis. The first one would be the legal conclusions are not entitled to presumption of truth. The second, complaint must contain well-pleaded factual allegations. And then the third, those facts must make relief plausible, not just possible. And in the reasoning process, we're going to explain we're going to break down the explanation and to explain the three standards. Okay, reasoning again. So this will be the focus the professor want to test us. And we would like to say that this is the core of the course, the reasoning process. Okay, let's start from the first one. The discrimination claims require purposeful intent, not just awareness of this disparate impact. So here, the court mentioned that if the plaintiff want to prove the discrimination, and the plaintiff need to identify the defendants did this on purpose. They have the purpose. So in that case, when the defendant must raise the alleged facts regarding showing the purpose. So that's point one. And next one, Iqbal's complaint alleged. The first one, Ashcroft was principal architect of discriminatory policies, and Mueller was instrumental in adopting them. And the third, but these were bare conclusions, not factual support. So that's the court's opinion. So you can say that Ashcroft was principal architect, but that is the conclusion, because it's like to say that Ashcroft violated the discriminatory policies or violated the anti-discrimination law. So this is the conclusion, the legal conclusion. And Mueller was instrumental in adopting them, a similar thing. So you're saying that Mueller was violating the discriminatory act. So they are not alleged facts. So even though and then they need some other facts to support. We cannot just assume they are correct. And next, the only facts alleged Iqbal was a Muslim detained in harsh conditions, and many detainees were Muslim. So this is the only alleged fact. And the court said this suggests a policy of security, not necessarily discrimination. So the court's logic is, even though we assume that your alleged fact is true, like say Iqbal was a Muslim and he was detained in the harsh conditions, the conditions are very hard, and many other detainees were also Muslim. So even though we assume those alleged facts are true, but can we prove that the defendants are violating the anti-discrimination law? Probably not, right? Because they are parallel, the actions. Probably not directly suggest suggest the Discrimination Act. The court said this suggests a policy of security, not necessarily discrimination. And lastly, without specific facts showing intent to target Muslims because they were Muslims, the claim lacks plausibility. So the court's idea is, even though we assume all the facts, alleged facts you mentioned are true, but we still cannot say they are violating the Anti-Discrimination Act because you are missing the intent. You must demonstrate that they have the intent to treat you differently because you are Muslim. But if you don't have the alleged fact about this, so it is just a legal conclusion. We cannot assume the legal conclusion is correct, is true at the beginning. Okay, holding a disposition. After all the analysis, and then the court held that Iqbal failed to plead sufficient facts to plausibly allege discrimination by Ashcroft on Mueller, and the decision and disposition is the Second Circuit reversed and complaint dismissed. So what is some significance and takeaway? What we can get from this case? We can see that the Iqbal extends Twombly beyond antitrust. Before the Twombly, people saying that the disposition in Twombly only apply in antitrust law, but the Iqbal's case extend the application, and it can apply. We can apply plausibility to all civil cases. And secondly, the case established two-step approach. The first one, disregard conclusory allegations. Conclusory allegations are the legal conclusion. For example, if I'm suing someone violating the anti-discrimination law, let's just say that it is Fair Housing Act, right? So if you cannot just say that the landlord rejected my offer because of I am black. So this is the legal allegation. So we cannot allow these happens. We cannot just accept this is true because these conclusory allegations. We need to have some facts and then to push and then to prove the conclusion, the discrimination. Some example would be at the same time we have two applications. We have two offers, and the one is a white person and the other is me, and I'm black, and I have better income, and I have a very stable job, and I demonstrate that strong financial status. But the other, actually, the job or the income is even less than me. But eventually, I got denied, and then the landlord accepts the white person. So these will be considered as strong alleged facts, because if we can prove this, and we can prove that the defendant treat the black people differently. But if you cannot just say the landlord rejected my offer because I'm black, so that is conclusory allegations. So the court cannot accept that. And also the second step is the court to evaluate whether remaining facts plausibly suggest entitlement to relief. And also, the takeaway from this case is the raises the bar from notice pleading, Conley, to plausibility pleading, Iqbal. And lastly, makes it harder for plaintiffs, especially in civil rights and discrimination cases, to survive motions to dismiss without more concrete facts. Okay, so that will be all for this case between Ashcroft and Iqbal. I hope you like this practice, and if you like my video, and please, I will see you in the next episode. Thank you.